flight. And away from that, Deputy Chief Justice Philomena Mwilu is accusing the Director of Public Prosecution as well as the Director of Criminal Investigations of hatching a plot to have her persecuted. Through her lawyers, Mwilu argues that the charges against her are malicious and tenable in law and meant to persecute and not prosecute her. The lawyers, led by Senior Counsel James Orengo, argued their case before a 5-judge bench yesterday. Well, let's cross over to the court there, where the case is still ongoing this morning, and take a look at the live pictures.
We have consulted, and although we'll be given the reasons once we break at break. These are the observations we made and the directions we made. First, we are guided by the Article 159 of the Constitution, so that in terms of matters like this, we should be looking at the substance as against procedure. We have noted, and it is considered by the first and second respondent, that there has been lateness of at least a day in filing of the submissions. But because this issue was not raised earlier, and we are not told the prejudice that the petitioner and the interested party may necessarily suffer, we will allow reliance on those written submissions. In respect to the bundles that are accompanying those submissions, we appreciate that indeed there could be a confusion that could be caused because we already have filed documents. But if it is a convenient way in which the first and second respondents will be making their arguments, we will allow them to proceed in that manner, but we will be cautious enough to ensure that that confusion is not caused to the minds of 5 judges. In respect to Mr. Mbita's document, we have noted, and this is not controverted by the petitioners and the interested party, that it is merely a compilation of the authorities which they are relying on. And insofar as extracts of the sections or the passages that were sought to be relied on had already been shared with the petitioner and the first respondent, we will allow the compiled bundle to be used, because it might as well be a convenient way in which the arguments can be made by counsel and with which the court can receive those arguments. So, and we also want to note that time had stopped running when all these arguments had been made. So you can proceed. Those are our directions.
My Lord, I'm extremely grateful to the court, and I can assure the court that there is absolutely no intention to confuse anybody.
My Lord, a decision has already been made. Perhaps my learned senior will just proceed with that case. And as he does so, let him not adopt a condescending approach we have seen in his preceding arguments. Where is really belittling us? We are a sovereign nation. Let him answer.
Can we have courtesy? I will ask Mr. Qureshi to do away with the asides. We're quite happy to do without them. I will ask the petitioners and the interested parties to keep away their asides also. Please, let us have a courteous process so that we can complete this matter. It's a long day, it's a long matter. We can't handle it. Mr. Qureshi, kindly put away the 9 remarks. We don't want to hear references to people's jurisdiction. Let's get on with it.
My lady, I'm very grateful, but I ought to make it absolutely clear. I was not the one who started about in this jurisdiction.
Counsel, it doesn't matter.
I understand. My lady, I'll take my direction from the court, not from my friends for the petitioner. But turning to the written submissions which are before the court, if I can invite the court to just open them up so that we can, the time that's just elapsed, we can try and make up for it. Page 2 As I was on the third of the core arguments, insofar as I can distill what was being said yesterday, and there were firstly criminalisation of a civil commercial matter, second the bank didn't make a complaint, and thirdly the examination of the minutiae of the charges. Now, so far as the third issue is concerned, the key response is reflected in paragraph 1.3 of my written submissions at page 2, and it is as follows. The petitioner does not dispute the facts underlying the charges. She does not dispute that she used court-headed paper and by letter dated 18th of August 2013 sought to procure funds in the sum of Kenyan shillings 70 million from Imperial Bank Limited, which subsequently entered into administrative receivership on 13th of October 2015. Furthermore, she does not deny that on the 23rd of October 2013, she procured Kenyan shillings 12 million from the same bank on an undocumented and unsecured basis, and I ought to add, with zero interest. The petitioner does not deny that in all material respects, she was acting for purely personal pecuniary advantage. This is not in any form of judicial capacity. Indeed, I mean no disrespect, but what was happening at this point in time was that the petitioner was engaged in buying and selling property. Furthermore, the petitioner does not deny that security in respect of her indebtedness held by the bank was released at her behest and her insistence after the bank entered administrative receivership and never replaced as promised, with the consequence that there is a substantial amount of indebtedness, some 49 million shillings, which is now unsecured. Indeed, it would appear that the proposed replacement security was, in fact, sold and could never have been provided. She does not explain why the allegation that the failure to pay stamp duty in respect of her numerous property transactions and that constitutes a criminal offence is objectionable, other than seeking to displace responsibility upon the shoulders of her solicitor, who I understand was a partner at her former law firm and was in any event, it's undisputed, acting as her agent at all material times. And she adds that, of course, it's open to the bank to pursue the lawyer interested party for his undertaking, but that undertaking, of course, the court will remember, was a curious undertaking. Because, firstly, it's an undertaking that it's impossible to perform because the relevant property was sold. And secondly, it's worth remembering that the very same solicitor at this material time, when the bank had entered into receivership, was acting in this transaction both for the bank and the petitioner. So in simple terms, as the lawyer for both parties, he was promising to do something to himself because he was acting for the bank. That, with respect, is somewhat strange, albeit very convenient. And one mustn't lose sight of the context. The context, as Lord Steyn in England said, with regards to judicial review, is everything. And here the context is alarming. Three observations.
That is Queen's Counsel Professor Hawar Qureshi, who was appointed by the Director of Public Prosecutions, Nuruddin Haji, to handle that case surrounding Deputy Chief Justice Philomena Mwilu. The DPP argued